Oh yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. Appreciate you being here this morning. I'm not sure everybody's excited about being as here as we are, but anyway, we certainly appreciate you being here. Want to take just a few moments and talk about our procedure before we get started. First of all, I know we've got experienced practitioners here today, but I always feel the need to go back over things. Each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve rebuttal time, you may reserve up to 5 minutes of rebuttal time. You do that after you come to the podium and you've introduced yourself, and then you can request it from the court so we can set the timer accordingly. Obviously, the appellee gets no rebuttal time. Our panel this morning consists of Judge Skip Frierson from East Tennessee. We appreciate Judge Frierson. He was so excited about these cases, he drove all the way down here just to hear them. Couldn't keep him from doing it. And Judge Arnold Golden from Memphis, who's also excited. And I'm Steve Stafford from Dyersburg. One thing I want to be sure and impress upon everybody is that we are live streaming these arguments today. So when we start, this will go out at the same time that you say whatever you're going to say. So be very careful about what you're going to say, because you cannot put the toothpaste back into the tube once it's gone, okay? Miss Angie, anything we need to take up before we get started?
No, Your Honor.
You may call the first case, please.
Lisa Kelley et al. Versus Nathaniel Root et al.
Good morning. Ben Gastel from Hertzfeld, Suholtz, Gastel, Linsky, and Wall. On behalf of the appellants, I'd like to reserve...
Could you pull that microphone down, please, just if you looked at... Okay. Great.
Is that better?
That's better. Thank you.
And I'd like to reserve 4 minutes for rebuttal.
All right. You may proceed.
We are here asking the court to reverse an October 21, 2022 order of the McNairy County Circuit Court granting the defendant's summary judgment in this matter. And the appeal is relatively simple. I think it presents kind of a question 1A and question 1B. Is there a genuine issue of material fact as to the defendant's liability when drawing all inferences in favor of the plaintiff? Our position is clear. We believe the trial court invaded the province of the jury and weighed the evidence and came to what he considered the truth, when we believe that there are genuine issues of material fact here. The court is very familiar with the summary judgment standard. The trial court's decision here is not entitled to any presumption of correctness on appeal, and any doubt exists as to the conclusions to be drawn from the facts must be resolved in favor of the non-movement, in this instance, the plaintiffs.
Let me pose a question for you, if I may. Are you saying that trial court can never view a video or look at a picture and make a determination?
I'm not saying that, but I'm saying in the facts of this particular case, the video in and of itself, coupled with the testimony that has been reached or accumulated through the course of discovery, shows that there is a genuine issue of material fact, especially as to what is in Mr. Root's mindset when he strikes Tyler Kelley. Obviously, the court is very familiar that there is video evidence of what we maintain and believe is an assault and battery on Tyler Kelley. Let me set the stage as to how Mr. Kelley...
Did he strike him?
Well, again, there's no doubt that Mr. Root comes into contact with Tyler Kelley. I believe that it's a hit. It is not a hit with his hand, but he comes into contact with him with his, it's kind of unclear from the video, but somewhere in between his wrist and his elbow, that portion of Mr. Root's forearm strikes Mr. Kelley. Mr. Kelley was a 14-year-old child.
Does anyone say that, is it Mr. Root?
Mr. Root was the basketball coach,
Okay,
yes.
Mr. Root. I get my names confused here. Does anyone say that Mr. Root struck Mr. Kelley?
Well, I believe that Tyler Kelley claims that he did, and I think that the video shows that he did.
Is that what his deposition testimony said?
Well, Mr. Kelley, yes, Mr. Kelley says that he is hit by Mr. Root. That he strikes him. Again, is a hit something that has to be done with the hand, or
Are you sure that's what he said?
I'm kind of surprised that this is the dispute, but if I can, use the video.
Sure.
Again, just to kind of set the stage here, this is at the end of this basketball game between Adamsville High and Scotts Hill. And there's a missed call. The real dispute stems from the fact that there was a missed call at the end of this game. And I'll play it for you. Just to set the stage, Scotts Hill is the team in black, Adamsville High is the team in white. Tie game.
You're going to need to speak into that mic.
It's a tie game, 68-68. Right there, you see that there's arguably a foul that is committed right there by the Scotts Hill player on the Adamsville player that causes him to lose the basketball. That is very material, I think, to this case. Scotts Hill gets the ball back, wins the basketball game with a layup. Now, interestingly, Mr. Root's about to make his first appearance in this video in the bottom left-hand corner. There he is, right there. There's no dispute that this is Mr. Root. On the screen, waving around, incredibly upset that that foul was not called. If you look at that's 27 seconds into the video. Now the melee will briefly break out on the court here, and then the shot will pan to the scoreboard. Melee here. Now, this gentleman right here, this child, 14-year-old child, the manager of the Scottsville team, this right here in this black hoodie, is Tyler Kelley. Now you can see he throws a punch, and then he is also struck in the face. And then, if we back up a little bit, Mr. Root will come back in a mere 17 seconds after he's seen angry, waving around, waving his arms, upset that that call was not made. And there he is, right there. The video shows that he is struck with the forearm of Mr. Root. Now, do you want to call that a hit? Do you want to call that a strike? You can clearly see that Tyler Kelley's head, a 14-year-old child, his head quite significantly moves as a result of coming into contact with Mr. Root right here at the bottom left-hand corner of his screen. 17 seconds after Mr. Root runs onto the court, upset that his team did not get the call. Now, we admit that Tyler Kelley should not have joined the fray that day, but he's the manager of this team. He didn't start it. He didn't participate in the game. He acted like a child because he was a 14-year-old child, and he got carried away, and he shouldn't have done that. But we maintain that it's the responsibility, it is the importance of the adults on that court to start acting like adults and take care and protect the children on that court who are acting like children. And you can also see that
Well,
when
let me
Mr.
go back and ask you the same question I asked you when you started your argument. At what point in time can the trial court view this video and determine what the video says?
Right. And I think that the trial court has a plausible explanation about what happens that day.
No, you're not answering my question. At what point in time? You said that the rule was not absolute. At what point in time can the trial court view this exhibit and say, this is what I see?
Well, again, if I may, I'll try to answer this question. I think that he can sit there and say that what he sees, certainly, and I think that that's well within the trial court's right to do so. Where the trial court goes beyond what it can do and what it should do is when it says, Nathan, in Mr. Root's mind, right at this moment, what is in Mr. Root's mind at this moment is not on the screen. Is he defending this child as he claims to be? Or is he taking out his anger and frustration on Tyler Kelley because he lost this basketball game? And that's where the trial court overstepped his authority, invaded the province of the jury, is when he starts making assumptions about what's in Mr. Root's mind at this particular moment.
So are you saying then that what the trial court found and what Mr. Root testified to are inconsistent?
No, I mean, I think that Mr. Root is certainly well within his right to testify about his motivation. But I think that, again, based on very clear Supreme Court authority, when we're talking about what is in the state of mind of an actor, those are issues for the jury.
Mr. Root testified whatever his state of mind was. The trial court viewed the video. The trial court, as I understand it, found that what Mr. Root testified to was consistent with what the video showed. Is that accurate?
Right. I think that that is what the trial court has done. Yes. But again, what the trial court is doing is then taking Mr. Root's explanation about what is in his mind and saying that that is truth. In any other context, if you had a criminal defendant.
So what's the line then?
The line, again, I think is very clear that the trial court, when you're talking about what is in the state of mind of an actor, and there are plausible explanations both ways. Mr. Root claims that he's de-escalating the situation and protecting his player. We claim that he's upset because this foul's been called and he's angry. And as a result, he's lost control of his emotions and takes it out on Tyler Kelley. Those are two plausible explanations of what happens on this video. And we think that in this particular instance, the trial court does not get to make that final call. The jury gets to make that final call. Because that raises a genuine issue of material fact. And again, we rely heavily on the Supreme Court decision that says, quote, the jury should be given an opportunity to observe the demeanor during direct and cross-examination of the witness whose state of mind are at issue.
You've used your time.
Thank you.
Thank you.
May it please the court, good morning. Nathan Tilley on behalf of appellee Nathaniel Root. With the court's permission, I would like to utilize 10 minutes of our time.
Okay.
And allow my colleague for McNairy County Board of Education to utilize 5 minutes of our time, Your Honors.
All right.
Your Honors, this case is about whether Coach Root's actions in protecting a player on his basketball team from the plaintiff's incoming punch gives rise to a cause of action for the plaintiff. And we ask this court to uphold the trial court's ruling granting Coach Root summary judgment. Your Honor, you ask my colleague about whether there's a different way to view this video. The thing about this case, though, is the testimony from both Mr. Root and Mr. Kelley are consistent with each other, and their testimony is consistent with what the video shows. So there's no facts in dispute about what the video shows. When Coach Root was asked about his actions, this is what he said. By the time I got to him swinging at one of my players, I realized that I could get hit. And I went in to block and protect myself because I wanted to get hit before one of my players. When I made the block, Mr. Kelley swung over my arm and I made contact with his shoulder. That's Coach Root's testimony from page 12 and 13 of his deposition. Now, when Tyler Kelley was asked about what happened, his testimony was consistent. He acknowledged that he entered the fray on his own. He voluntarily did so. That when he did so, he punched an Adamsville player with his right hand. That after he punched that Adamsville player, and that Adamsville player is falling back or being pulled back or going back, whatever it was, he was moving away from Tyler. Tyler then attempted to punch him again. He rubbed his right hand back over his shoulder, clenched his fist, and was trying to punch that Adamsville player again. He admits that at that time, Coach Root made contact with him, but that Coach Root's arm was bent at a 45 to 60 degree angle. He admits that Coach Root did not make contact with his face. And he admits that Coach Root did not punch him, despite what he pled in his complaint and never amended. He admits that there was never a punch from Coach Root to him. So the testimony from Tyler Kelley and the testimony from Coach Root are consistent with each other. There are no disputed facts about what happened. Now, the video is going to show it's going to be consistent as well. So I just want to show a few things.
Does the plaintiff, the appellant, admit that what the coach did was defensive?
He admits that the arm was at a 45 to 60 degree angle, Your Honor. I think that is clearly defensive, and it is, I liken it to a force continuum. It's lower on the force continuum than the force that Tyler was using, because Tyler is actively trying to punch an Adamsville player while Coach Root is coming in, and the video will show this, in a defensive posture with an arm at a 45 to 60 degree angle. That's actually a lower level of force than Tyler was using at the time. So, start right here at 32 seconds. The plaintiff is right here. I'm circling him in this black hoodie. When the fight breaks out, he chooses to enter the fray. And he is about to punch this Adamsville player, number 24 in white, in the head. And now, as you can see, after he's done so, the Adamsville player is backed away from him, and he has revved his fist back behind his head. Mr. Kelley has. You can also see Coach Root in the frame there. And you will see that Coach Root is attempting to get in between Tyler's incoming punch and the Adamsville player. And that's exactly what he did. Now, Your Honors, we have a slow motion version of this that zoomed in so that you can see it a little better. You can see this is Tyler right here. I'm circling. He's about to punch the Adamsville player. And here you go. I've paused it at 14 seconds. You can see Coach Root, what is he looking at? He is looking at Tyler pulling his arm back behind his head, clenching his fist, about to hit the Adamsville player, or attempting to. And then you're going to see Coach Root come in with a defensive posture with his left arm to try to block the punch. Your Honors, Tennessee law protects this behavior by Coach Root. We've cited Tennessee Code Annotated 38-2-101, 38-2-103. They provide that when someone acts to prevent the commission of an offense like this, to protect somebody else and to protect themselves, they are immune from liability. And that's good public policy. We want our coaches, when something like this happens, we do not want to signal to coaches and teachers that they are subject to liability for intervening in these types of situations, especially when the force that was used, it wasn't even to what Tyler was utilizing himself. It was less than the force that Tyler was utilizing himself.
So how do you deal with opposing counsel's argument that it's important what the state of mind is of your client here, in that we need to, the jury needs to determine the state of mind, even though the facts, that you've got the deposition testimony, you've got the video, but still it's up to the jury to determine the state of mind.
I think, Your Honor, when we look at the specific claims, we're going to find that there's nothing in the record that would create an issue of fact as it relates to state of mind that could state a claim, that could survive summary judgment. So when you look at the 14th Amendment, for example, you have to show that the behavior shocked the conscience. And we've cited case law that even slapping a student in the face intentionally with that state of mind isn't enough to shock the conscience. So there is no 14th Amendment claim. So then you get into Tennessee state law claims, and you have the assault and the battery claims. As it relates to the battery, first it has to be an unlawful contact. And it has to be a contact that's done without consent. Well, you got the plaintiff or the appellant has two problems there. One, Tyler voluntarily ran into a fight. He has consented to physical contact, and he's especially consented to physical contact of teachers trying to stop the fight, to try to pull players away from each other. But secondly, because of Tennessee law, because of the Tennessee statutes that we spoke about earlier, the contact by Mr. Root isn't unlawful. It can't be, because the video shows, he testified to it, Tyler didn't dispute any of this, that when he acted, he did so at the time that Tyler was trying to commit a battery himself on an Adamsville player, and that Mr. Root was getting in between him and Tyler's incoming punch. Well, under Tennessee statute, that's protected. And the trial court found correctly that there is no facts in this record that dispute any of that, that dispute that that's what's happened. Now, at the beginning of the case, if you read the complaint from appellant, he made wild accusations that Coach Root punched Tyler, that he violently punched him, that he engaged in fighting. All of those things appear in the complaint, but when you look at the video footage and hear the actual testimony in the case, none of those things are true. So the answer is there's nothing in the record to suggest otherwise that would allow this to go to a jury, Your Honor. I'm about out of time. If you have any questions for me, any other questions, I'm happy to answer them, but I do want to make sure I leave plenty of time for my colleague for the Board of Education.
As far as in the record, we've got the video that appellant's counsel showed us, and then you showed a slowed-down version, or both, or a slow-motion version. Are both of those in the record?
They are, Your Honor. They're both going to be found in Volume 8.
Okay,
Yes.
thank you.
Thank you, Your Honors.
Good morning. Catherine Phillips on behalf of the appellee, McNairy County Board of Education. Your Honor, the appellants essentially have two remaining claims against the board. The first is their Section 1983 claim for failure to train and supervise, and their second is their assault and battery claim. The first claim I will address is their Section 1983 claim. To succeed on a failure to train or supervise claim, the appellants must show that the board had an official customer policy of failing to adequately train, supervise, or discipline its employees in a particular matter, and that such official policy or custom was adopted by the official makers of policy with deliberate indifference towards the constitutional rights of the persons affected by the policy or custom. The standard of deliberate indifference in a Section 1983 case is stringent and requires proof that the board disregarded a known or obvious consequence of their actions. The appellants may prove deliberate indifference in two ways. First, they may show a pattern of similar constitutional violations in the face of which the board continued its failure to train, and second, they may show a single constitutional violation accompanied by a showing that the board failed to train its employees to handle recurring situations that presented an obvious potential for a constitutional violation. In this case, the appellants cannot prove deliberate indifference under either of these theories. Specifically, there's no evidence that an incident similar to the February 5th, 2019 fight had ever occurred within the district. The testimony in this case shows that the February 5th, 2019 fight was the only fight that has ever broken out at a basketball game in the district. Therefore, the appellants have not shown that the board was on notice that it needed to conduct training for large fights at sporting events. Further, there's no evidence that Coach Root had a history with anger management or that the board was aware of any such issues with anger management. Although the appellants allege that he had a history or problems with anger management, they've not produced sufficient evidence to show that Coach Root did in fact have these problems. Further, there's no evidence that the board was aware of any instances involving Coach Root that would demonstrate a history of issues with anger management. Therefore, the appellants have failed to show that the board was on notice that it needed to train Coach Root on anger management or that it needed to supervise him more or differently than any other employee. Because the board was not on notice that it needed to conduct training regarding large fights at sporting events, and it was not on notice that it needed to train Coach Root on anger management or supervise him more or differently than any other employee, the appellants have failed to show that there was a pattern of unconstitutional violations or that the board failed to train its employees to handle recurring situations that presented an obvious potential for a constitutional violation. As a result, the appellants cannot prove a failure to train or supervise claim pursuant to Section 1983, and their claim was properly dismissed by the trial court. The appellant's second claim against the board is their assault and battery claim. In Hughes versus the Metro Government of Nashville, the Tennessee Supreme Court held that the Tennessee Governmental Tort Liability Act does not permit governmental entities to be held vicariously liable for assault and battery. Rather, it requires a direct showing of negligence on the part of the governmental entity. Therefore, in this case, the board cannot be held vicariously liable for the assault and battery allegedly committed by Coach Root. Rather, the plaintiffs must make a direct showing of negligence on the part of the board. In response to the board's motion for summary judgment, the appellants conceded that they're not entitled to bring a negligence claim against the board because the board is immune pursuant to the civil rights exception contained in the GTLA. Because the appellants have conceded that they're not entitled to bring a negligence claim against the board, their assault and battery claims must fail as a matter of law, since the board's liability for assault and battery requires a direct showing of negligence. Therefore, their assault and battery claims were properly dismissed by the trial court. I have no further argument. You have any questions?
Thank you. No.
Thank you.
I believe you have 4 minutes.
If I can just rebut one statement that was made by my colleague, Mr. Tilley. The idea that Tyler Kelley, a 14-year-old child, who, as somebody who is also tall and skinny and weighs about 100 pounds when sopping wet, that he could ever muster the same amount of force as a man, grown man, who's a former basketball star at the University of Memphis, who's running full tilt at him, is simply belied by the facts and simple physics. Mr. Root came at Mr. Kelley with enough force to throw him off his feet, throw him into bleachers several feet away. And if you saw at the end of that video, enough to make the person who actually witnessed it, and I'll use the second video. At the very end, this gentleman right here, oh, sorry, it is in fact the very end. This gentleman right here, to believe that he needed to separate Mr. Root from Mr. Kelley. Mr. Root entered the fray that day, and I admit Mr. Kelley should not have done that. And I admit that Mr. Kelley threw a punch. And he was a 14-year-old kid who got caught in a moment that was just a little bit of madness. And we admit that. But again, if you go back to how Mr. Kelley enters the fray, about the basketball player that he first strikes, that player himself is also an aggressor in throwing a punch at that particular moment. People are throwing punches here. Let me back up. Children are...
Was Coach Root throwing a punch? There doesn't seem to be a distinction being made between being an aggressor versus a defensive position.
Right, and so that's part of what I'm trying to get at, is that Mr. Kelley and Mr. Root are doing the exact same thing, in the sense that Mr. Kelley should not be throwing a punch, and I get that. But Mr. Root should not be using violent, aggressive means to quote-unquote de-escalate the situation, because that's not de-escalation. De-escalation is peacefully removing people from hostile situations. That's de-escalation.
Opposing counsel said that there are no facts in dispute that make Mr. Root's state of mind important.
I disagree with that wholeheartedly, because
And
if
what
he's
facts?
not in a defensive position, he keeps claiming that the unrebutted video shows that he's in a defensive position. That's a defensive position. This is how you separate people who are aggressors in a fight. Not striking them in the shoulder, face, neck, whatever you want to call it. So yes, we believe that the state of mind of Mr. Root, because if he's being defensive, sure, he's entitled to the presumption that his use of force was appropriate. But if he's angry at his team losing this game, like he was wildly running around the court 17 seconds before this interaction, if he's still angry.
Did he testify he was angry?
No.
Did anyone testify he was angry?
Well, the video shows that he's angry, right?
I mean, was there any other evidence that he was angry? He testified he wasn't angry. What was the contrary testimony
Well,
that he was angry?
he testified in his deposition that he's angry at the call. He doesn't testify at his deposition that he's angry at the exact moment that he's striking Tyler Kelley. But it's 17 seconds after that.
Well,
If you can, if you can calm yourself from anger in 17 seconds in the middle of this type of melee, you have far more emotional control than the average human being.
Is there a difference between being angry and excited?
I think in this instance, yes.
Okay, thank you.
Thank you.
Thank you, counsel. We appreciate your briefs, your arguments. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. Thank you. Thank you. You may be excused.